Welcome to This Explainer. Today, we're unpacking a massive shift in how we approach family law and support in India. We'll be looking specifically at the new Bharatiya Nagarik Suraksha Sanhita, or the BNSS of 2023, and how it totally transforms the concept of maintenance. We're moving away from looking at maintenance as some sort of perceived penalty against a spouse. Instead, we're going to explore how the law actually uses it as a critical, literal life-saving mechanism for social justice. So let's jump right in with a question that really gets to the heart of family law and systemic abandonment. When a household completely fractures, what actually happens to the dependents? The people who might not have an independent income, who rely entirely on the primary earner for their very survival. Well, without legal safeguards, these individuals face the terrifying prospect of sudden destitution. The law recognizes this profound vulnerability, and that is exactly where the new maintenance provisions step in. To really understand sections 144 to 146 of the BNSS, we're going to hit 5 key areas today: the purpose of maintenance, who's actually eligible, the legal precedents shaping the law, the path to relief, and finally, how these orders can be modified or canceled.
All right, part 1, the purpose of maintenance, preventing destitution.
To ground these legal concepts, let's picture a hypothetical, but honestly very common story. Meet Raj and Meera. Raj works in Delhi, and Meera left her job after they got married to care for their son, Arav, who's still a student, and Raj's elderly dependent mother, Shanti Devi. Now, after some years, the marriage breaks down. Raj moves out, and, he simply stops sending money home. Suddenly, Meera, Arav, and Shanti Devi are staring at absolute financial ruin. They have zero independent income. And it's at this exact moment of crisis that Section 144 of the BNSS is triggered. And this brilliantly illustrates our core concept. Section 144 steps in here because maintenance is all about basic human survival. We're talking financial support for the absolute essentials: food, a roof over your head, clothing, medical expenses, and education. The magistrate isn't looking to punish Raj for leaving, not at all. The objective is purely to prevent Meera, Arav, and Shanti Devi from facing destitution and vagrancy. It's a protective measure, not a punitive one. Moving on to part 2. Who is actually eligible to claim this under Section 144? The law anchors eligibility on one single unifying factor: the absolute inability to maintain oneself, period. Whether you're a wife, a minor child, a major child with an abnormality, or elderly parents, if you cannot maintain yourself, you are entitled to support. This perfectly covers the family in our story: Meera as the wife, Arav as the minor child, and Shanti Devi as the elderly mother. Now, here's where it gets really interesting. How does the law define a wife? Historically, courts have been incredibly liberal with this term to ensure that technical legal loopholes don't leave vulnerable women high and dry. It's not just a legally wedded wife currently in the marriage. It explicitly includes a divorced wife who hasn't remarried yet, or a woman who's been neglected after a separation. The focus is always on the dependency and the relationship, basically prioritizing social justice over rigid technicalities. Let's pivot to part 3, the legal precedents that shaped this law. You literally cannot talk about maintenance in India without bringing up the famous Shah Bano case. It was a total game changer. This monumental ruling transformed Indian law by establishing maintenance as a secular right. The Supreme Court effectively said that even a divorced Muslim woman can claim maintenance under criminal procedure law if she faces destitution. The underlying principle there is profound. Religious personal laws absolutely cannot be used as an excuse to defeat a human being's fundamental right to basic survival. And this philosophy didn't stop there. It built up through a series of landmark cases. In Ramesh Chandra Kaushal, the court declared the law must always favor the weaker dependents. In Rajneesh versus Neha, they laid down strict guidelines for income disclosure to make sure maintenance is actually realistic, not just some token amount. The Chanmunya case reinforced that technicalities shouldn't defeat social justice, even if a couple just lived together for a long time. And in the Badshaw case, the court protected women deceived into fake marriages, stating flat out that a wrongdoer cannot benefit from their own fraud. All of these rulings ensure courts prioritize immediate practical justice. Which brings us to part 4, the actual path to relief under Section 145. So how does this work in practice? Under Section 145, the process is deliberately designed to be accessible. Going back to Meera, she would file an application before a judicial magistrate. She essentially needs to prove 3 things: that Raj has sufficient means, that she and the family cannot maintain themselves, and that Raj has neglected or refused to support them. Importantly, Meera doesn't have to sit through a decade-long, complex civil trial. The proceedings are summary in nature. They're quasi-criminal, evidence is recorded quickly, and the whole shebang is designed purely for speedy welfare. But wait, what if even a speedy summary trial takes, say, 6 months or a year? Are Mira and her family just supposed to starve in the meantime? Absolutely not. The magistrate has the power to grant interim maintenance. This is immediate, temporary financial support granted while the main case is still pending. It bridges the gap. It ensures the dependent family avoids immediate starvation and extreme hardship while the legal gears are turning. Finally, Part 5. Modifying or canceling these orders under Section 146. Look, life happens, right? Financial realities shift, and Section 146 is highly adaptable to that. Say Raj gets a massive promotion and his salary jumps from 40,000 to 2 lakh rupees a month. Or if inflation skyrockets and Arab's education costs multiply, Mira can petition for an increase. Conversely, if Raj loses his job, suffers a severe disability, or faces a drastic, legitimate increase in his financial liabilities, he can petition to decrease the maintenance amount. But, quick caveat, mere excuses won't work here. The courts require hard proof of these changed circumstances. But what about cancellation? Say Mira remarries. In the eyes of the law, that new marital relationship creates a brand new support structure, so that previous maintenance order ends. Similarly, if she becomes entirely self-sufficient, if the parties decide to get back together, or if it turns out the initial claim was based on fraud, the magistrate has the authority under Section 146 to modify or withdraw the relief entirely. Now, it's absolutely vital to note that a wife can lose her entitlement to maintenance altogether right from the get-go under specific conditions. If she refuses to live with her husband without sufficient cause, lives in adultery, or if the couple mutually agrees to separate permanently, the claim can be denied. But remember, courts are pragmatic. Factors like domestic violence, extreme cruelty, dowry harassment, or a husband taking a second wife are absolutely considered sufficient cause to live separately and still receive that maintenance. Bringing this all together, Sections 144 to 146 of the BNSS cement a genuinely powerful constitutional philosophy. Nobody, absolutely nobody, should be abandoned to destitution just because a relationship broke down. The law deliberately prioritizes human survival, dignity, and practical social justice over rigid technicalities. If you take away one thing today, let it be this: maintenance is not charity. It is a fundamental legal duty that arises directly from the relationship and the resulting dependency. So, I'm going to leave you with this final thought to ponder. Having this robust, socially minded legal framework in the BNSS is an amazing first step. But how can we, as a society, ensure that these vital protections are genuinely accessible to every single vulnerable person who needs them, regardless of their background or resources? Thank you for joining me on this explainer, and keep exploring the system.